So welcome to the ultimate panel of Inframarginalism and Internet, a conference on markets as wealth distributors and the implications for tech policy. We've got a wonderful group of panelists here for you. Unfortunately, however, Gerrit de Geest, who is scheduled to present on this panel today, is unable to join us. He's got a bad case of stomach flu, he tells us, and sends his sincerest regrets. So I'm very pleased to be able to introduce our moderator, Herb Hovenkamp, professor at Penn Law and also at Wharton. We also have with us Przemek Palka of the Future Law Lab at Jagiellonian University in Poland. Also with us is Mike Gutentag of LMU's Law School. And we also have, I'm delighted to say we also have Katarina Pister here of Columbia Law School. And finally, Matt Dimmick of Buffalo Law. So with that, I'll turn it over to Herb.
Well, thank you, everybody. So glad to be here, and we'll get right to it. Because we're down to 4 speakers, I think we can safely give everybody about 10 minutes. And Katarina, I had you down to go first. Are you ready? You need to unmute, Katarina.
Mute, then I will share my screen. Here we go. Share. Can you see this?
Yes.
Yes. Okay, so I will basically draw on my relatively recent book, The Code of Capital, How the Law Creates Wealth and Inequality, which is basically a book not so much about how surplus is being distributed, but how surplus is being created and very often channeled from the get-go into the hands of some. So my maybe implicit theory about the law and about the state that I probably have to articulate more clearly in future work is that law is really differential access to power. As a colleague, a sociologist, had told me in an earlier project we were working on, Akas Ronas Tas actually was it. He said law is differential access to power. So I think one of the key issues we have to ask ourselves is how power is institutionalized in different societies, and there are layers of institutionalizing power through law, public law, private law, and as I will say in a few minutes, I'm focusing mostly on private law. So the core message here is that the way in which we have, or in which parties have used and been able to avail themselves to harness power to organize their relationships with one another in what we call markets is not neutral. It's also not random, and that's really the source of creating surplus for some, perhaps at the expense of others. So access to superior legal coding strategies is really what creates the surplus ex ante. What I discuss in the book is that capital is really a wealth generating asset. So you can turn, in my language, you can turn any object, any promise to future cash flows pay, or any idea into a wealth generating asset by grafting, with the help of law, a set of priority rights onto these assets or for their holders. So I distinguish 4 different attributes, and you really need 3 out of 4. The first one is priority. You have to have stronger rights than everybody else to the same asset. So property right is an example that gives you priority over others. And the test case is always insolvency or bankruptcy. So when a debtor is bankrupt and the debtor still is in possession of something for which I have the legal title, I can take it out and all other creditors have to yield. If I have a secured interest, a collateral, like a mortgage or a pledge, to one of the assets that the debtor has in possession, I can take it out and the remaining creditors have to yield and I can enforce against this asset. If I have none of the above, I'm an unsecured creditor and I typically get a haircut because insolvency, of course, by definition is the situation when the debtor doesn't have enough assets to fulfill all claims against him by various creditors. So priority is important. We rank different legal rights all the time, and the ability to claim priority rights is quite powerful. Durability is another quality or attribute which is much less talked about, but really does a lot of the work in creating wealth over time. Because what it does, it really protects assets from too many different creditors. It's basically the reverse of what I just said. But if you are able to use legal shields to separate some assets from others, then you expose certain fractions of your assets to some creditors, but they don't have access to other assets which we have shielded off into a different pocket. We use corporate law and trust law to do that. The third important attribute is universality, which means that these rights, these legal rights, are enforceable not only vis-a-vis parties with whom I have negotiated these rights, but against the world. Creditors who didn't even know that there were other creditors in the boat have to yield once they understand that somebody has better title. So universality really means extension in space. And then the final attribute is really the way in which financial assets attain durability. So for financial assets, it's less interesting to keep them together fixed, but you want to exchange them all the time. And of course, when private financial assets lose their value in times of crisis, what you want is not only the ability to trade them, to pass them on to others, but you want to convert them into safer assets. And the safest asset in the hierarchy of financial assets is typically legal tender or state-issued currency. And of course, there we have a hierarchy as well. But if you can put your hands on dollars in times of financial crisis, at least in this world, you're still better off than under different circumstances. So convertibility is basically a substitute for the durability attribute when it comes to finance. Now, in the book, I describe how different simple objects, I call them assets together, you can think of them as resources like land, farms, debt, and know-how, has been, all these assets have been transformed or coded as capital with these legal modules. So these are the legal modules that do the work of grafting priority, durability, universality, or convertibility on different assets. It's contract law, it's property law, it's collateral law, it's trust law, corporate law, bankruptcy law. Other legal institutions, legal devices can do something similar, but what was so striking for me, which is why I wrote the book in the way I did, was that these institutions have been with us for centuries and have done roughly the same job for all these different types of assets. They're tweaked on the margin a little bit, but it's basically the same story over and over again. So trust law, for example, was used by the landed elite in England to protect the new property rights they had received in their land from too many different creditors. It's a combination of trust. The entail is a bit more complicated, but we don't have to go into the legal details here. But they basically shifted the interest, the legal interest, to the assets they owned into a legal construct that protected the interest from their creditors by saying they belong to future generations rather than to the current owner, and therefore the creditors could not enforce. We're using the same device for securitization, derivatives, of course, tax avoidance strategies, and so forth today. So there's an interesting continuity, and that told me why these institutions are so important. So where lies the coding power, or wherein lies the coding power? One important aspect is to have access to the right lawyers, but ideally lawyers in the right legal system where you have a lot of flexibility in coding these assets. I call the lawyers the masters of the code, not because they control the assets, the clients control the assets, but they know how to do the legal coding, how to convey land in the old days, how to securitize and use other structured finance techniques today to create new types of assets that find willing buyers, right? How you do tranching and securitization, how to make sure that you don't conflict with some tax rules, how to make sure that you can trade the same thing in multiple markets under different jurisdictions. That's the work that lawyers basically do. It is particularly effective when you are in a legal system such as the common law system that facilitates bottom-up lawmaking. Basically, you enter a transaction, you build these assets. You don't have to ask anybody. You have to comply with some regulation to be sure. But in principle, you can try to create a new type of asset based on analogies to things that have already been accepted in the past, and just wait that somebody else polices it in the future and might then strike it down. But even then, you have made some gains in between. seen. Another way to enhance your rights is to lobby for legislative safe harbors. We have seen this a lot in recent decades when the financial sector basically had exhausted all the private legal coding techniques and was trying to get protections for new types of assets and for new types of markets by lobbying for safe harbors. Best known are bankruptcy safe harbors. So if you have a particular type of asset, a derivative or a repo, you were exempted from the rules of bankruptcy that apply to everybody else. So I said before, bankruptcy is the asset test. It is the asset test. If bankruptcy exempts you, you are exempt from certain rules in bankruptcy law, you actually have a better right than everybody else. And so that's a way to create new types of property rights if you want. And then, of course, what we also see increasingly is that lawyers enter into new kinds of territories, if you want, where they don't really have firm legal authority to go by. They don't have case law, but they write legal opinions, basically building on old and older case law to say, actually, you know, had we case law today, we probably would go in this direction, and therefore we can do this new thing. But at the same time, most lawyers will avoid presenting any of these cases ever to a real court of law, which might strike it down. And if you have coded many transactions in a particular new technique, you don't want to have a code strike it down. So ironically, the same mechanism, the common law courts that were so useful in creating or expanding the coding strategies that I described, that becomes an increasing risk when you already have a complicated system and lots of clients owning them, because the same courts might strike it down, and that could come at huge cost. So you see, therefore, a shift into private dispute settlement, basically private settlement without going to court, but then settling before you get a decision, or using private arbitration. And then, of course, what we also do see, I think, throughout history, this is not only before financial assets, but throughout history, we see a bias in the way in which courts have validated certain types of interest. So by and large, courts have been more likely to validate new coding strategies, no interest, if they promised greater monetary surplus. So land rights for, let's say, capitalist production rather than cultural protection. And so there have been, by and large, especially in the West, not very protective of non-economic interests, such as cultures, a particular way of life of, let's say, indigenous people. I describe a case of the Maya in Belize. So just to put this together, in my world, law is a social scaling technology that relies on centralized means of coercion. But the important thing is that we have institutionalized these centralized means of coercion in such a way that private parties can have access to that. So it's in the relationship of citizens to citizens or private parties to private parties. They can use institutions such as contract law, corporate law, or trust law, even property law, and organize their relationships, being assured that they will be enforceable. Not 100% guarantee, but the probability of enforceability increases when you have good lawyers who can exploit existing gaps in the law to do so. So whether or not you have access to these coding strategies, of course, depends on a couple of factors that are critical. Is whether you have resources, whether you have really good lawyers, and whether the lawyers can make arguments that resonate with the institutional biases of the legal institutions, such as courts or even regulators, that they have to convince. So that's really all I want to say right now. I hope that what people get is that I understand sort of the law as a coding strategy, and code not in the terms of codification, but more like software coding or the genetic code, where you use these tools, you put them together, you recombine them in different ways, and thereby create new types of assets and strategies that grant the holders of certain types of assets stronger rights, better enforceable rights, or more durable rights than others.
Thank you very much. Appreciate that, Katrina. Okay, Semak, are you ready?
To go, yes.
Thank you.
Thank you very much, Herb. And once again to Ramzi for invitation and for putting this event together. It's a great pleasure to be here with all of you, not least because in Krakow, Poland, from where I'm calling, it's currently 10:20 p.m. and this is the closest I've gotten to having a nightlife since last summer, so double fun. The paper that I wanted to discuss today is about terms of service, about online platforms, more specifically about the consumer unfriendly terms within those terms of service, the CUTs for short. And the paper argues that the cuts are socially undesirable, both on economic grounds, they're inefficient, but more importantly, they actually transfer wealth from the less affluent to the richer parties in the market relationships. And on democratic grounds, because they render self-regulation by the market much more difficult, and they generally replace the rule of law with the law of the firm. Hence, I argue that what we should do is to act to have the cuts removed from the socioeconomic life. And what I mean by we and what I mean by acting, I'll get to at the very end. The argument is what we need right now is a new narrative and sort of a new story about how we should think about terms of service and why we should think they're under 5 steps. First step is the empirical claim that the cut is widespread in the terms of service of online platforms. If you read them, and I sort of had to for this project and a couple of other projects, you'll notice that essentially all terms of service contain them, and some of them are very familiar from the old boilerplate discussions we had. There's exclusion of liability, there are clauses pertaining to dispute settlement, choice of forum, choice of law, mandatory arbitration. There are clauses about the right to unilaterally change the contract, and sort of we're used to that. And then there are consumer unfriendly terms that are sort of specific to online platforms. Those include house rules, how you're supposed or allowed to behave in a particular platform, the right to delete or modify the content or the entire account of the user, the right to collect and use personal information that is in privacy policies, and then not really a clause, but rather an omission of a description of what the service is. If you read the terms of service of Facebook or of Google, you'll never find any promises about what actually the service will be. It's just sort of a general statement of what they want to give you, but no actual promises, plus a waiver of warranty. Second, and this is critical, I argue that when it comes to terms of service, we should look at them through a different lens than we used to look at the boilerplate contract. On the one hand, of course, they are like boilerplate contract, but on the other, there's a couple of circumstances, both when it comes to the contents of the terms of service and of the broader social context, that just ask for a little bit of a different lens. And there are 3 important points here. First, as we've heard so many times during this conference already, many of these platforms are monopolists, right? They're either actual monopolists or they have a de facto monopolistic dominant position in the market. So the whole story about a consumer having a choice and sort of shopping for a better product, including better terms of service, better boilerplate, doesn't hold here. Second, online platforms are not only firms providing a service, but they are, in a very almost literal sense, the governors of the online spaces. They not only provide the service, but they also make the rules for those spaces. They enforce those rules, and they retain control about the code, what is possible to do there, about the algorithms, what you will see, and they have the ability to block you, to delete your account, to delete your digital content, etc. And third, the cuts, the terms of service contain all the clauses that allow platforms to collect and use personal information. And this is within the context of a market that is not regulated and where the traditional boilerplate clauses exclude any liability, exclude any warranty, and essentially make it impossible for the consumer to go to court. So third part of the narrative, first step, is the economic claim, where I want to challenge the traditional boilerplate story, which is the following. Boilerplate might strike us as you know, wrong or undemocratic, but there are price consequences to it, right? If you read the boilerplate apologies, they will say because those clauses are in the contract, the price can be much lower. And that means that many more people can enjoy the product. So it's just the elite lawyers that sort of really want to go to court, but most people really don't care about it. And the claim I want to make is that the actual transfer of wealth needs to be seen through the lens of the ability of someone to whom damage occurs to internalize this damage. What do I mean by that? The concept I propose in the paper is a concept of reverse insurance. In a traditional insurance, we all chip in a little bit so that when it comes to the damage that happens to a random person, that unfortunate person will get compensated. And with cuts, the price effect goes the other way around. We all pay a little bit less in the traditional story, but once the unfortunate person suffers damage, she or he will have much lower chances of getting compensated because they've waived the liability and they can't really go to court. The problem here is that monopolies are not really charging prices in money. They're squeezing money out of using the personal data. So we don't really know how much, people save or do not save. And at the same time, once the damage happens to a particular consumer, they can't recover it. And then on the societal level, and that's the fourth part of the narrative, the whole idea of not regulating the digital platforms, usage of data, design of code, the things that we knew were problematic since the 90s, was that in this new emergent environment, the market will do much better job than the government regulating top down. And whether that was a correct or an incorrect argument is a different question to ask. We might, see arguments for one or the other, but the precondition for the self-regulation of the market to take place is either that there is actual competition, which we have seen there is not, or that there's access to court, right? That if someone actually thinks that certain practices are, shouldn't be taking place there, you can go and sue the company. But if we've all waived the right to sue, we've all waived the right to class action, we've all waived the liability, we won't really be able to do that. So I'm not trying to make an argument about all the boilerplate. I'm just trying to say that when it comes to terms of service, in the context of digital capitalism, the cuts are really undesirable. Which gets me to the last part, which is the question of how to get rid of the cuts. And there are many ways to do it. One of them is to through legal change. I think that once we sort of see the consequences of their operation in the context of digital capitalism, I think that not very powerful right now unconscionability doctrine might be useful, especially in connection with the second thing, which is creation of mandatory consumer rights by the state legislatures. There is more and more case law showing that that state and federal courts are more willing to recognize the unconscionability claim when a particular contract is explicitly supposed to deny the consumer right granted by the legislature. And of course, we could see regulation on the federal level. But we don't need really the law to work here. This could also happen through market pressure. We could see, consumers getting together and getting scandalized, having, public opinion see that the cuts are widespread. But this is where I think what really matters is the story, right? If we believe that thanks to those cuts, many more people can access the services, then we'll probably like them. But if we sort of see that not only they transfer the wealth from the less affluent members of the society to the rich, right? Because they're not capable to internalize the damage once it happens. And in the monopolistic situation, basically the surplus is being taken by the monopolist. And at the same time, they sort of undermine the idea of democratic society, which is at the same time a rule of law and the ability for the market to self-govern. We might be much more, we might find it easier to actually master either the political will to regulate or just the public pressure to get rid of them. Thank you so much. This is everything I wanted to say, and I really look forward to.
Okay, thank you. And Mike.
Mike, and I am going to try and share some slides as well. Oh my gosh. Let me try that again. Huh. Ramsey, any theory about when I click on the little share box, nothing comes up or it stays blocked? Well, so much for sharing slides. Oh, you know what I can do? Oh, I'll send Ramsey my slides. Okay, I'll send Ramsey my slides, and then hopefully that'll work. Sorry, let's take a sec to do this. Thank you, Ramsey. I appreciate everyone's patience. I just made them a couple hours ago, so I feel like very much the artists.
Like hot rolls from the oven.
Okay, I'll send them to Ramsey, and we'll see what happens in the meantime. Okay, so thank you, and it's so amazing because I feel like my presentation, it also is very much related to boilerplate, and I wish Garrett were here as well because it sort of fits between the various discussions. So what I've tried to do with these slides is to start with a simple heuristic of what we've been doing these last 2 days. And in that heuristic, I want to introduce and suggest there are, did you receive them, Ramsey?
I got them.
Okay. It's 3 slides. So the first slide is basically trying to introduce a simple heuristic of what we've been doing these 2 days. And at the top of the slide that at some point you might see or not is the efficiency analysis of law, which I think of as since Herb's here, I'll say the second wave of law and economics, the sort of modern wave of law and economics. And that school looks at law as a tool to improve efficiency. And then the second lens is the lens that I think Ramsey is trying to champion and introduce with this conference, which looks at the law as a way to share inframarginal resources in ways that are fair and efficient. And then the third way to look at the law is what I'd call more of a humanist approach, where the law is a tool of autonomy. And there you are. I don't know how discordant it is, but that's the gist of the idea. That's what we're talking about these 2 days. And what Ramsey and I would argue is that middle box, the inframarginalist lens, looking at law as a tool to share surplus, is woefully underdeveloped. And so when I look out in the land of legal scholarship, I mentioned insider trading the first day. Another area where I think you see this lack of, or this blind spot, is when you look at the literature on boilerplate. So if you want to go to the next slide, Ramsey, if you could, or not. I'm going to seem to be cursed by technical difficulties. So if I look at the law of boilerplate, I think I see this gaping hole where there are plenty of folks who have talked, and I apologize to the many people I've left off this slide. There are people like Douglas Baird, Omri Ben-Shahar, I'll focus on first, who make the argument that Chemik referred to, that look, boilerplate is just another product feature. And then there are people like Oren Bar-Gil who say, yeah, but there's some market failures here that we need to adjust for efficiency reasons. I see all those people as really looking at boilerplate from an efficiency perspective. And then on the other side of the spectrum in the boilerplate literature, as I read it, there's like Margaret Jane Radden and Robin Bradley Carr, who think about, well, what about the effects on personhood and autonomy of this boilerplate? And I feel like these two groups, well, one, I don't think they really communicate that well with each other. But I think more importantly, what's really been missing or what the opportunity to contribute is this inframarginalist lens. Because when I look at it, a lot of the impact of boilerplate is inframarginal. And so if we even if we think about it from an efficiency perspective, the inframarginal stakes are a lot higher in boilerplate than the efficiency stakes. So Ramsey, if you go to the next slide, and about how much time do I have to talk through this?
I think you're okay. You got about 6 more minutes.
Oh, great. Oh, okay. So let me talk through what I view as the contribution of this this graph and to the boilerplate debate, and why it's an example of where the inframarginalist lens can help us make better policy decisions. So the first thing to highlight is this is a very standard supply and demand curve to start with. In the black, we have we see the clear equilibrium where supply equals demand. And then the addition I make to the graph is to add this idea that boilerplate acts as a hidden markup, which I really don't think is a very revolutionary claim. People like Oren Bargill and a large cast of characters have talked about behavioral exploitation. It's not unusual to think that what companies or what sellers are doing is they're hiding terms, and in fact we have plenty of research showing this is what happens. They're hiding terms that benefit them. And we have to add one more assumption to make that into a hidden markup. We have to assume that consumers are not aware of this. I mean, if consumers are estimating the costs of these hidden markups, they're not hidden at all. But I thought there was a recent study on restrictions on having your iPhone repaired, which are actually quite expensive. And it turns out that consumers systematically underestimate the cost of that particular boilerplate provision. So it's not surprising to think that consumers are underestimating these costs, which is why the hidden markup is a higher demand curve than the actual demand curve. Another assumption that we need to support, because this is an out of equilibrium claim. The other assumption we need is that the players have enough market power to sustain this out of equilibrium position. And I think there's a lot of research now that we would expect companies to be able to maintain markups, or we've seen evidence that companies are able to maintain markups throughout the economy. So then why don't I, before I go to the policy ramifications, I want to make sure I'm explaining this clearly. What we see is we have the price HM is the price of the hidden markup perceived by the consumer. And then the price HM actual is the price actually received. And that gap is the hidden markup. Okay, so what would an efficiency law scholar look at this see? They would see the Harburger's trial, D&E. They would say, oh, well, there's some waste there. The waste consists of the fact that certain consumers are not willing to pay as much as the product actually costs, and they're nevertheless buying it. But if you look at the larger scale of economic effects, you see, I think, some potentially much more important and significant effects. I want to focus on, I guess, A, B, and C. And look at all that. That is transfer. That is inframarginal transfer from the buyer to the seller. And if we're talking about firms that have boilerplate versus consumers, that's almost certainly inframarginal transfer from those who are less well off to those who are better off. So if this is an accurate picture of the outcome of this practice, we have an equitable reason, a welfare economics reason to prohibit this practice. And then the other side of it is the waste side. What incentive do firms have to expend funds A, B, and C? Well, they have every incentive to spend that money if they're effectively able to take that money to switch from consumer surplus to producer surplus. I mean, obviously, this is the insight of the rent-seeking scholars. But as I said yesterday, they decided not to actually look at market transactions. But here, I think we have a very clear market case for why we do not want to have consumer boilerplate. So to summarize, this is to me, a compelling reason for regulation, not just because of D&E, not because of trying to tweak the efficiency considerations, but because of the inframarginal considerations. And so I would say, going, I think, a step farther than Shemek went, I would say we should have a mandatory set of consumer-friendly boilerplate provisions that are in place for all consumer transactions. Okay. That's all I've got.
Okay, thank you.
Thank you, Ramsey.
And then finally to Matt.
All right, let's see if I can get these slides to work here. All right, does that look good? All right, well, thanks everyone for staying for this final session, I believe, and like everyone else, I'm thrilled and honored to be invited and to be with all these great scholars. I've seen some great panels and discussions today, so grateful for the opportunity to be here and share my research. What I'm going to talk about today is some of my, I'm working on a book with the tentative title, The Law and Economics of Income Inequality. And so I'm going to share one chapter from that book that focuses on intellectual property. And I'm investigating this classic question raised by Capello and Chevelle, whose names have come up many times already in their 1994 article on whether legal rules should be used to redistribute income, or whether taxes should be the only instrument for addressing income inequality. As I've developed this project, there's something that that's been, I think, made clear to me, which is that in emphasizing efficiency, Capello and Chevelle are not ruling out, incidental income inequality reduction effects, right? So if antitrust law or IP law increases efficiency, and at the same time, incidentally reduces income inequality, right? No problem. But in that case, it's the efficiency rather than the redistributive effect that justifies the change in the rule, right? So, right, to restate this, I think a little bit different way, right? The question is not whether legal rules can be used to redistribute income, right? I think in the case of, again, an antitrust or IP law, it's relatively straightforward how that can work, right? The question is whether they should be used to redistribute income, especially given the availability of this alternative that we have, which is the income tax, right? And Capello Chevelle's main argument is that because the income tax is always more efficient at redistribution, we should stick with the income tax and not other legal rules. All right, so there's, I will say more about that argument because that's important for showing why I think IP can be used to redistribute income, even if it's inefficient to do so. So I'll come back to that later. There's lots of contributions, right, that critiques the Capello and Chevelle argument. This list is completely not exhaustive. There's many other great contributions I could have added here. I don't have time to really go into details, right? But I think what I'm trying to do is maybe make the discussion a little more concrete, right? So for example, a lot of this literature talks about whether tort law can be used to redistribute income, and that's fine, right? I have no problem, and especially I have no problem with, abstract and theoretical analyses. But, who thinks about using tort law to redistribute income, right? It's usually not the first place you go to when you're talking about addressing income inequality, right? Something like intellectual property, though, the stakes I think a little clearer and a little more palpable. So what I'm trying to do in the book is look at specific areas of law where we might think the law is particularly important for addressing income inequality, and try and counter the impression I think I have, which is that Capital and Chevelle ultimately are saying, yeah, maybe you can, maybe there is a theoretical case for using legal rules to redistribute income, but it's rare, it's unlikely, so we shouldn't really bother thinking about it very seriously. All right, so here again, because of time, I won't spend a lot of time discussing this, right? But this is some recent research from Aegon and others on the effects of intellectual property on the top 1% share of income. And essentially, they're making the argument that it's both substantively and statistically significant. That especially the past 2 or 3 decades, the change to a more robust IP regime has increased income inequality. So that justifies, I think, giving attention to IP laws as one of those areas where the law may be more consequential for redistributing income. All right, so let me return back to the Capital and Chevelle argument and unpack that a little bit more, right? Basically, the argument is this double distortion idea, right? So using legal rules to redistribute income distorts work incentives or labor supply fully as much as the income tax does, but also creates inefficiencies in the activities regulated by legal rules, right? So because one distortion is better than two, it's better to use efficient legal rules, which only have one distortion, and then use taxes to redistribute. So one example. This is the example that they use, right? So they talk about using a damages rule in tort that varies with the income of the defendant. Rich defendants have to pay more, right? And if you do this to, say, redistribute 1% more of income from the rich, right, then you're going to have this first effect that's identical to, a tax effect. Just increasing the marginal tax rate 1% will also influence labor supply in exactly that same amount, right? But on top of that, you'll have this legal rule distortion, right? The rich will they'll be spending too many resources and time and precaution to avoid accidents, right? And that's a waste. That's inefficient. So this legal redistribution has these two distortions. One that just mimics the tax effect or the labor supply effect, and the other that distorts the activity that's regulated by the legal rule itself. Right, so you can achieve the same exact amount of redistribution just by increasing the marginal tax rate 1%, right? And you have the same size and distortion as you do up here in the labor supply dimension, but then you don't have this additional cost over here, right? So that's the argument, is it's always going to be better to use the income tax to redistribute income and just pick efficient legal rules to maximize the pie, right? These savings here from moving from the legal rule redistribution to an income tax redistribution, those savings can actually be used to make the poor better off compared to this regime, the legal redistribution regime, right? All right, so how does this work in IP law, right? At first, it looks like, if you think about reducing the length of a patent duration, or narrowing the patent scope in some way, right? That you're going to have a double distortion, just like Kaplan and Chevelle warn against, right? So if you're reducing the value of the patent so that the income return is smaller, right? You're going to have a labor supply tax distortion, just like a change in the income tax. but it's also going to distort the incentives to invest in research and development, right? And if there's less, if the patent length or the scope of patent protection that you're choosing in favor of a more redistributive regime is moving away from inefficiency, then there will be some loss in inventive activity, if you want to call it, right? So right at first glance, it looks like you have the same exact problem as you do in other cases with this double distortion in trying to use intellectual property to redistribute income. But there's actually, when it comes to intellectual property, there's a third distortion, right? Which is that there are pro-competitive effects, right? If you're reducing patent length or narrowing patent scope, that usually means that you get the monopoly effects of patents are reduced and you get more competition. And that is a distortion that goes in favor of increasing wealth. So it goes in the opposite direction of the first two distortions, right? It's offsetting rather than compounding. So that's a key assumption, I think, that's in the Capello and Chevelle paper that they don't actually ever justify, is that when they talk about distortions, they're always assuming that they're going to be, additive or compounding in some way. But if you think about it and you think about theory of the second best, right? I don't see why that will generally be the case. And I think here again is one reason why I think it's helpful to be more concrete and looking at specific areas of law. When you think about IP law, you realize that there is this third distortion, but it goes in the opposite effect. All right, so ultimately it's an empirical matter whether, right, this, if this offsetting distortion is large enough, what that means is that it actually might be more efficient to use IP law rather than the income tax to redistribute income. Or I like to put it better, because this can still be technically an inefficient change. It means it's less inefficient than the income tax at redistributing income, right? Ultimately, that depends on how all these different distortions add up and their net effects, and that's an empirical question. But that's, in my opinion, that's where we should be. These should be empirical questions. They shouldn't be questions that can be answered with theory, which is, I think, what Capello and Chevelle are trying to do. All right, so just two main conclusions. Again, I think it's important to remember that in the double distortion argument, if it's a change in antitrust, a change in intellectual property, or from our discussion earlier today in consumer law, right? Just the mere fact that it reduces income inequality is not necessarily a problem for the double distortion argument, right? If it's also increasing efficiency, then that's by itself is reason enough to adopt the change. The tougher question is whether, right, using legal rules that are inefficient, whether they can be less inefficient, as I said before, than the income tax. And as in this chapter, I'm arguing that given the existence of these three offsetting, right, not compounding distortions, the answer is a possible yes. So let me end there, and looking forward to questions and discussion.
Okay, great. Thank you. I think I'd like to just throw out a question first, and then maybe the panelists talk to each other for a while, have a discussion among themselves, and then in another 15 minutes or so, we'll throw this open to questions from the audience. So if you have a question, please enter it into the chat portion of the computer screen. I've got kind of a fundamental question about what went wrong, or did something go wrong? If you look at the rise of neoclassical economics in the first half of the 20th century, it was dominated by concerns about distribution, particularly as between capital and labor. It was certainly true of all of the progressives. Richard T. Ely wrote a book in 1912 entitled Property and Contract in their relation to the distribution of wealth. Thorstein Veblen was heavily concerned about the distribution, John R. Commons. Interestingly, and I think contrary to what some people believe, it was a period of very, very significant economic growth. We started collecting GDP data in 1929, so we really have to project economic growth prior to that. And of course, the Depression was a major glitch. But overall, looking at the period from, say, 1890 to 1950 or so, it was a period of a lot of concern about distribution and fairly aggressive economic growth. I don't think I could justify blaming the Chicago school for this. There's got to be more going on. There's something I've always thought we would want to recover, something, not everything, but something from that period that we just don't have. Does anybody have any thoughts about that?
Really uninformed because it's not my area, but it seems like it's a confluence of two things. You know, our major enemy after World War II was the Russians. And so it could be part of a whole, you know, Cold War, anti-communist, anti-sharing, anti-socialist. So certainly if you were on the other side of sort of pro-distributionists, and the people who were distributionists might have been a little nervous. And then at the same time, you had, you know, the public corporation, you know, maybe becoming I know the public corporation really emerged around the same period you're talking about, right? The early 1900s is when we started to have the dramatic growth of the public corporation. But maybe they got smart and picked up steam and funded those folks in Chicago, right? I mean, we have a lot of funds going into that side of academia that we don't have going into this side of academia. I'd love your thoughts, Herb.
I know academics. I mean, they usually resist where the funds are going. But the fact is,
Herbert, can you just explain, clarify again which period you were talking about sort of what you want to resurrect in terms of growth, the post-World War II period or the earlier period?
The teens and the 20s up to the Depression were very rapid growth.
Yeah, but also a big booming stock market that crashed, no?
Yeah, then we had a big crash in the stock market, and then we had another period of fairly rapid growth all the way through the 50s and 60s. But nevertheless, there was also a great deal of concern about equality that began to disappear from neoclassical economics in the 1970s and 80s in particular. And we suddenly got very, very concerned about efficiency. And interestingly, the more concerned about efficiency we became, the slower our economic growth went. That's a bit of a generalization, but it's roughly true.
Yeah, I think that's right, and it's kind of interesting. I mean, I think Thatcher and Reagan in their political configuration, and then we have basically the ideological or theory-based academic response. But I think Thatcherism and Reaganism was a response to perceived inefficiencies of the previous systems, right? And I think there's no doubt that some of the policies that were put in place after World War II. And that first helped create growth. And we're living in a dialectic world, right? The same things that can create growth at some point might get stalled if they preempt future innovation and new developments in the future. And I think there was a correction that perhaps was needed, but I agree with you that there was an unfortunate shift in a very different direction, which was completely ignoring actually the distributional effects of what is happening and the beliefs that somehow this would take care of itself. We could just focus on something else. I see this mostly as an political ideological shift that emanated in the US and the UK, and from there, through competitive pressures and institutional change, such as opening capital flows, etc., was transposed elsewhere. And then, of course, on top of that, you get the collapse of the former socialist world, which seems to give further justification for this enormous shift and sort of the winner-takes-all attitude that has reinforced the ideological shift that preceded it.
One thing I would add, I agree with both Michael and Katarina's stories, 99, 100%. I guess one little thing to add that I found interesting in reading Capital and Chevelle is they often will cite, I think Richard Musgrave, who was writing in the 50s or whatever, and was developing this idea of public economics. And I think with like what Katarina was saying, talking about the ideological development of economics, and especially the formalization of economics, and the idealization of this market as this perfect mechanism for allocating resources. One consequence of that was this idea that really the market should only be used to allocate resources. And there's the strong division of labor between the market and the government. The government, through taxes and transfers, redistributes. And, the two never, the twain never shall meet, right? You keep them separate. And so even though that acknowledges a space for redistribution, I think by sidelining it in that way, it has the effect of demoting it at the same time.
What is interesting, the Arrow-Debreu model goes back to the 1950s, right? And Arrow himself writes a book in 1974 or so about organization where he says, for certain things, yes, there must be coordination, right? I just think for certain things, the market mechanism is really great. So I think that, there have been these strands in theoretical thinking, but why they have been magnified and become sort of the dominant discourse, and you dismissed everything else, even though the proponents of these strands are much more differential when you read them yourself. That I think is difficult to explain with anything but a major ideological shift.
Okay, then I've got one other question, and I know even less about the answer to this one, which is how do you distinguish an inframarginal wealth transfer from one that has an impact on the margin? It cuts across all the areas we've been talking about. So suppose we're going to make IP policy that is better, that transfers wealth in more pleasing ways. How do we do that without confronting the issue that we think so much of our incentive to innovate comes from IP? Can we transfer that wealth without affecting where the margin point is? Same thing with boilerplate, right? And the one I'm most familiar with is the numerous Supreme Court decisions on compulsory arbitration. If we think of arbitration as nothing more than cost savings in resolution of disputes, you would think both sides would embrace it, right? Everybody would be better off if we could resolve disputes more cheaply. But the fact is that compulsory arbitration has turned into a pretty powerful anti-consumer device. Anybody have any thoughts on that?
I have a thought. I think ultimately we're going to end up with a general theory because you cannot disentangle the two effects. But where we are now is, if you read the technical efficiency literature, at least in the law and economics sphere, you only see the efficiency analysis. It's a denial of the inframarginal effects. And so I don't think you, so what I'm trying to do is develop clearly sort of as much as you can, pure case inframarginal effects. But the ultimate answer is going to be a blend. So when I look at the sophisticated tax policy analysis of, let's say minimum wage, same Ramsey's talked about, the efficiency people tell you it's a bad idea, because the simple-minded efficiency people tell you it's a bad idea because it'll, discouraging hiring, it'll distort supply and demand. Emmanuel Saez and those guys will take a real look at it and say, look, this is going to have both efficiency and redistributive effects. And we've got to weigh that all in with a full social welfare function. I don't think we're anywhere near that in the legal academy, because even the idea that those other inframarginal effects are real is just starting to enter the thinking.
Yeah. Does anybody else have a question for another panel member?
I have a question for all three of them. I guess if you don't mind, keep talking. Katrina, I would think, when I hear you talk, the area that sparks the most anger and frustration for me is, tax and trusts and estates. I read that story about Leon Black, avoided $1 billion. How much, it seems to me like that's where your scholarship can really have the most, poignant impact. And I'm just wondering if that's where you want to go, or how much you think about those kinds of issues.
In the book, I made a much more general argument, and I think it also relates to what Matthew said, and I see maybe his book is sort of a different take on what I was trying to get at, which is to really think about the institutions that we take for granted in property rights as, from the get-go, coding different wealth positions for different people. So if you have access to them, you can use them. Property rights get created, and they don't get created by a social contract. They get created physical violence and legal recognition of title. And once the landowners had title in England, or the settlers in the US, they use that title, of course, to monetize, but they don't stop there. But then they use trust and estate law and other legal devices to protect their newly gained wealth against the next. So the illusion that at some point, because we have created property rights, we can now enter into this sort of neutral market thing and just reallocate them in a Coasian fashion has never existed in no sphere. So I think where I get actually more, I think with land, it's critical enough, and lots of people have got dispossessed. What for me the most fascinating story is that goes into the intangibles, is when we are legally basically further dressing up assets that owe their very existence to the law. So a financial asset is an IOU, and then you dress it up with securitization devices, and we call it structured finance for a reason, and collateral, etc. Intellectual property rights is, nobody disputes that this is it is created, doesn't exist outside the law. But then when intellectual property rights become the most important source of wealth for corporations that are widely traded, then we live in a different world. And that, just to make a link also to Prem's presentation about the digital world, I think it's interesting because the digital coding itself becomes a new source of power, but it's also deeply imbricated with our existing legal systems. It's corporate law, it's antitrust law, it's of course intellectual property law, it's trade secrecy law. So how these devices are being used to create new assets. And just to briefly respond to a question that Ramsey asked in the chat is, is this any different from, just power? Well, it's all about power. In my world, it's really all about power. The question is, power in the law is a social resource. And the question is, who has access to this for what purposes? And we can sort of make lots of assumptions and declare something like that to be a market. But I think what I'm trying to do is to unpack these assumptions and not to limit this to a narrow little field, but look more broadly about how the similar mechanisms have been used to create differential access to a common resource, and law is a common resource.
Okay, I may open this up to the audience. Does anybody on the panel have another comment or question they'd like to make?
There's several comments in the chat box that I think were referred to my presentation, so I'd be happy to.
Oh yeah, go ahead. Go ahead.
Yeah. So one, Jennifer Bird-Poland says that IP distribution is even more strongly correlated with wealth inequality than income inequality. You know, I have no argument there. That's just more grist for my mill. You know, so they're just stronger reasons, I think, to think about IP as a mechanism for redistribution. So I totally agree, and I think that's important. Daniel asks about, says changes in IP law to reduce patent monopoly change distribution to be less distorting, not more. So, you know, so part of this is the way Caplow and Chevelle use the word distortion, right? Distortion is not necessarily, I mean, for Caplow and Chevelle, they almost always mean it's negative, but in the broader language, a distortion is any departure from optimality, whatever that is, right? And so, I think with IP, right, we have this classic trade-off, right? If we strengthen IP law, that gives more incentives to invent, but then there's this anti-competitive trade-off, right? So there's some optimal choice, right? When I'm assuming that we start from optimality to make the argument that even an inefficient change in IP law can be justified in redistributive grounds, and I think that's what hits the Caplow and Chevelle argument the hardest. And then Ramsey talks about the Atkinson-Stiglitz model, and I agree on one level. Once you grant the full or you depart from the strong Atkinson-Stiglitz assumptions, I think Caplow and Chevelle the argument that's another area where the Caplow and Chevelle argument just falls apart. Usually Caplow and Chevelle, they respond to that by saying, you know, once you're allowing correlations between consumption preferences and labor supply, then you get this, you know, because consumption preferences are so diverse and cover, you know, millions of different goods that you encounter this impossible you know, data problem of how do you need to know what consumers' preferences are across a range of millions of different goods, and that just makes the optimal tax problem even harder. You know, again, I'm not gonna fight you if you're gonna tell me that is, you know, completely reasonable with our you know, data and technology today. I'm not gonna argue with that. I grant that assumption in my book just to show that you know, you can still poke holes in the Caplow and Chevelle argument, even if you grant their assumptions. So there's some more, but I'm gonna stop there. I don't want to take too much.
Matt, I need to step out for just 1 minute. Would you mind taking over for just a second? You can either
Sure.
talk or ask someone. I'll be right back. Thank you.
Yeah. I'll open it up to any more questions or comments.
I can referee for a second if you like, Matt. So what's I find really interesting here is there's sort of this, you know, shared concern about the law as power here, and there's sort of different approaches to conceptualizing it. So, you know, we have Katerina has this sort of very high level, you know, view of how the law works to structure power, and at the same time, we've got in Shemek and Mike's papers this sort of, you know, how do we deal with, you know, particular, you know, terms that are being imposed on us as power. And then, you know, and Matt is looking specifically at the sort of distributive consequences of it. And so question I have is, can we pull these different strands together, you know, in a way that maybe even gets us back to that first law in economics movement synthesis, where you had, you know, people like Robert Hale, who, you know, wrote, you know, very passionately about the coercive nature of the law and incorporated that into a kind of inframarginalist, you know, rent theoretic economics, in which you would look specifically at how, for example, the terms of injustice is talking about, how those terms actually, you can measure them quantitatively, the extent to which they redistribute value from one person to another. So I'm interested in in terms of the next steps for theory, how can we reproduce the synthesis that existed a century ago?
Well, there's a complication to the synthesis, is that we can't think about these issues anymore without thinking in a transnational fashion, or at least bringing in choice of law rules and the ability your legal system as well, and maybe, and also I think the digital dimension. I want to bring this back in because I do have a chapter in my book where I discuss whether the digital code might replace the legal code. Ramsey, you also asked me a question about that. I think there are limits to what you can do in the pre-coding in terms of incomplete contracts and incomplete law. So but I think with AI and learning technologies, even that might become less relevant. So there are two things here. I think that the digital world sort of suggests that the power centers are shifting, or the source of power are shifting. And the other thing is that we are not living in closed systems, and we can no longer pretend that we are, which we might have still done in the 1930s. And I think that complicates things, because we have more system and more than one source of power.
Well, riffing off that a little bit, it is, so Katerina is referring to a question I put in the chat, referring to Thibault's paper about blockchain, in which he makes the argument that, we're getting to a point where we can sort of reify, literally reify, legal rules and turn them into sort of this self-executing code. So once once that rule has been implemented, that's it. You can't get out of it, right? Unless you shut the whole system down. And so, this does seem, the one important distinction, I would say, or one important distinction between the law, the human law, and the reified law is that the reified law seems like it's going to be harder to break. And so, so that, that would seem to suggest that, a sort of dystopic, future in which, at least in the past, we could sort of escape through the interstices of enforcement, and we may not be able to do that going forward.
The question is,
go ahead, Katrina.
I was just going to say, I think some will get out of it and others won't, as often is the case. So how, and I think, we've seen this in a number of spectacular cases already, that actually the digital coders can go offline and renegotiate, but not everybody will have the ability to do exactly.
Well, Herb, I took over briefly.
Go right ahead. You're doing a good job.
All right. Well, so so I'd like to turn the question though also to Przemek and Mike. So, for example, Przemek says, well, we've got these, we don't have, we've got these big platforms and we don't have competition, and they're able to, they're basically able to dictate law. So they have a law-like character because, we don't allow challenging the terms of injustice that Przemek refers to, that they're sort of dictating, to us. And so, so where do we go from here? So, we've known for a long time that there's something called, corporate legislation, which is when we have, monopolies and you have nowhere else to go, the firms are able to dictate their terms to us as if they were legislatures. And, one of the responses we've seen through antitrust has been, this idea, well, we just break all the firms up and we create more competition. But the flip side of that, as we talked about in the last panel, is that, maybe we don't want to break the firms up, right? Maybe the networks are good, they're useful and they're helpful, and so we need to regulate them instead. And that's kind of what that's sort of what the first progressive movement seemed to come to, right? It started with antitrust as break things up, and then it moved to this idea that, well, and this was certainly Robert Hale, who was a big public utility regulationist, he's moved to this idea that no, we should regulate, these big firms because we can take value from them. We should just determine the prices that they can charge. And so would you support that? Or I seem to read your paper as, saying we can use a reform of consumer law to effectively allow a kind of de facto regulation of the terms and thereby the prices that the firms are charging us.
So if I may first, maybe I think it's really interesting to bring the realists into this discussion, right? Because from the European perspective, one of the things that realists said that we never listened to was that the distinction between private and public law is sort of, just a misnomer, right? All the law is public law, and all the law is about distribution of power in the society. It's just the question of whether you do it directly through regulation or through protection of certain property rights and enforcement of particular contracts. And what happens when we start enforcing the contract terms that basically take away people's rights, either right to sue or liability is excluded, is we sort of distribute more power to the corporations, right? So this is sort of the first moment when there is regulation, say, of tourism industry, but we say some of these rights might be waived. Then there's the next step when we don't even regulate the digital industry, right? Like there's no federal law about privacy, there's no federal law about data use, and still we allow the market to self-regulate within the firm's ability to waive it. And my sense is that, and that sort of gets to Herbert's first question, this whole move was predicated on the assumption that, okay, maybe there indeed is something democratic or normatively important that we're losing here, but there's also something great that we're getting, right? Which is better efficiency of the market, bigger pie, and better allocation, which, I think in the 1990s, as Katarina mentioned, after, the Soviet Union is down, there was this moment when we sort of held that belief, right? And right now we sort of see that this is just not what's happening. So we basically face a political question. And that, I think, is where the American judiciary really forgot the insights of the realists, right? That whether we want to enforce the boilerplate or not, in the end is a political question about the distribution of power, which partly translates into the economic distribution of wealth, but partly just translates into distribution of power, which effects we can't really foresee, right? The question about arbitration, there are certain contracts where arbitration might be worth a lot of money, but then there are certain contracts where we really don't know. The example I use in the paper is Headspace, the meditation app, which promises you peace of mind. But if you actually read the terms of service, you've waived your right to sue and your right to class action, and you've excluded any liability. So I don't know. But what can be the damage that you will suffer using this meditation app? I don't know. Like, maybe you will, maybe you won't. Maybe something horrible will happen that we can't foresee yet, right? Maybe they will use this data in a way that will be really harmful. But it's really difficult to judge it at the beginning. So we can't really say whether it's efficient to have it there or not. And it's a political question on whether we want market to sort of self-deal or whether we want to put some kind of either democratic or judicial control over that. And that's I don't know if that answers your question, but I do find it interesting how through the realists sort of there is this strand in American legal thought, which when it comes to boilerplate right now just seems to be forgotten.
But it certainly does seem as though, something I think that you encounter when you go from like taking first-year contracts in law school to then going, later and taking an antitrust class is, you encounter, these situations in contracts class in which you've got these terms of adhesion and so on, right? And the solution that's posed to you is always, well, you should go out and buy from a different firm if you don't like the terms that are being provided to you. And then you say, well, there are no other firms. And then someone says, well, there's another area of law that's going to deal with that problem for you, and that's antitrust. But then you get to antitrust and you find out that there's a lot of different reasons why you might not want to actually intervene in that market. For example, breakup might be really destructive, right? Really inefficient and so on. So, okay, so antitrust is out, but you contract law is not going to save you either, and conscionability is basically dead. So what do? The answer, the realist era answer was, pervasive regulation, right? It was you regulate the firm, you have a rate regulator, they use their power to approve prices as leverage to really dictate what the nature of the product is going to be. And it's really interesting that, in all of this debate we've been having, all this progressive, resurgence, what's missing is the pervasive regulation approach, right? The one that went out in the 70s, just as antitrust enforcement was going to take a dive as well, and that really hasn't been resurrected. And even we had in the last panel a really interesting, discussion about this EU Digital Markets Act, which is this proposed law which would regulate the tech giants. But even there, the emphasis on the law is not. It's not really on pervasive regulation of the product. It's much more on trying to sort of promote entry into markets. And so I'm curious, given that a lot of the work on this panel has a lot of relation to the sort of progressive era thought. How do you feel about rate regulation generally as sort of this missing, third term in the debate about reform these days? I mean, is that a problem?
Is there anybody who wants it? I mean, I always like to look at the more optimistic story, which is not rate regulation of the phone company, but rather the breakup of the phone company, which was able to maintain the network while decentralizing it to a fairly awesome degree. I mean, today you can pick up your Samsung cell phone in Los Angeles and call somebody on a Southern Bell line in Florida or somewhere. That phone call is seamless, and there are literally thousands of firms participating in that network. It's very decentralized, and we have a very good private equivalent of that in the development of cellular communications now, and sort of the pending development of autonomous vehicles. Lots of participants with lots of intellectual property rights. However, they do make an advance commitment to license them on fair, reasonable, and non-discriminatory terms, with the royalties to be set by agreement, or if necessary by arbitration or litigation. So it is a way of creating intellectual property rights and distributing their results more widely. Now, there's a very unfortunate decision in the Ninth Circuit, FTC versus Qualcomm, a couple of months ago, that took away antitrust as a tool for enforcing FRAND obligations, even in a circumstance where it seemed pretty obvious to a lot of people that antitrust should be applied. But we can contract out of strong intellectual property rights in situations where it works, and we do it a lot of times, right? Think of email, where by voluntary agreement, everybody can talk to everyone else. That there's no court order or legislation that forces that, but your Outlook account can communicate with my Gmail account and vice versa. Blanket licensing, a little more complicated story because it started out with a consent decree, but today we've got millions of artists sharing their music at basically an agreed upon royalty rate with millions of other people. Or in the realm of academic journals, JSTOR, where you can search thousands of academic articles simultaneously. You don't have to search them individually. Royalties are not in the cards there, unfortunately, for those of us who write articles. But there are ways to do this through private ordering systems if we want to put our minds to it. And there, I think the basic story is dominant firms do not like network sharing because they're dominant. We're not going to get Facebook to do this voluntarily, but non-dominant firms are eager to share because that's how they get more access to markets.
This is a really, really, really important point, is that people actually can figure this out and share. One of the, I met a mathematician who teaches at Northwestern, I think, at some point, who said that Google has actually used the data that we compiled in the wikis and Wikipedia. And if you eliminated Wikipedia from the Google searches, the powers would be much, much lower. So they basically have captured and privately exploited a common source. So people can do that. The real problem is to deal with those who are trying to privatize it and to capture it for themselves. I mean, so they're private solutions, they're non-state solutions, but they're shared cooperative solutions rather than hierarchical solutions where some, winners again take all. So I think that's, and I do think that, in comparison again to the 1930s or thereafter, we have new ideas and new technologies how to organize and to govern. And the missing element, as Herbert was suggesting, is really to put our minds to that and to think about how to protect these spaces.
Well, if no one wants to jump in on that particular question, I'll go. We've got a couple more questions in the chat that I'd like to honor. So Jennifer Bird-Pollen says, the point about assets that are kind of legal fiction seems so important to me and fundamentally changes moral questions about distribution we've been asking for centuries. Makes me think about Locke talking about how we can measure the appropriate amount of wealth a person can hold in terms of how much wheat he can have before it starts to rot. Piketty makes this point too right. There's no upper limit to capital anymore now that it isn't tied to land. And that's in response to Katerina's work, whose book Jennifer is going to buy right away. To Matt, Dan Greenwood says, IP creates monopoly distortions. Perhaps that's a good trade-off for the incentives. More likely, there are better ways to incentivize, but it seems quite strange to grant Kaplan-Chavel's language. Weakening the monopoly is a new distribution, not a redistribution. There's no monopoly that exists prior to the law. Do either of you want to follow up on those comments?
Jennifer already a text, so thanks very much, Matt, but I think she's absolutely right about the point that our ability to sort of enlarge the wealth creation capacity has a lot to do with just moving beyond tangible assets that have a real side. But the wealth creation was always the law. It's always of this additional social construct. And that goes back to Veblen and others, of course. It's nothing new and common. So it's the working rules of society that do the trick. But it's more explicit in these non-tangibles and can be expanded further. A great point, though.
Matt, any thoughts on Dan's comment?
Dan, right? I think I agree. There's, it is weird to talk about a redistribution as if some prior point is some pure ideal standpoint against which, some non-political standard against which everything is measured. It's always distributive. So I agree with that point. I use Kaplan-Chavel's language because that's the I want to contest them on their terrain. So for better or for worse, I grant them their strange language.
Okay, great. Well, it looks like we're at time, but we did start a couple of minutes late. Each of our panelists and our distinguished moderator a chance for one final word.
Okay, can I go first? I want to do two things. One, thank Ramsey again for an amazing conference, truly amazing. I think almost single-handedly, which is an unbelievable feat in of itself. And the other thing, for those who had any thoughts or comments on what I said today, and I'm assuming that Shemek and I are going to talk at length after this, this really is very much a first thought project that I'm presenting. So I really do welcome any feedback that people might have. That's it.
Shemek, any thoughts?
I can only join in congratulating you and thanking for this. It was a wonderful event, and I do hope that we continue the discussion within the inframarginalist lens. Thanks so much.
Moving now
yes,
to
thank you.
Herb.
I wasn't really a member of this panel, but I learned a lot. So thank you very much for inviting me. And thank you too, Ramsey, for a wonderful conference. It was great.
Thanks. Matt?
Thanks to all for participating. Thanks again to Ramsey for the invitation. Really appreciate it. It's great to share some ideas and get some helpful and interesting responses. Wish me luck as I try and finish this book.
No, I just want to thank as well,
and
and sorry for. I just had other things going on, but I really enjoyed the cross-disciplinary discussions across contracts and boilerplates and digital and antitrust and IP in this panel. It was very informative. And thanks for Ramsey for inviting me. Appreciate it very much.
Well, thank you all. So this is the last panel of the conference.